Welcome back. Stand Your Ground has long been a controversial law, but now it's getting even more controversial. The previous version was signed into law in 2005. It required defendants to prove that they had to use force in self-defense, but under the new version of the law signed earlier this month, the burden of proof is now in prosecutors' hands. Essentially, in pretrial hearings, prosecutors have to prove that Stand Your Ground is not applicable. Joining us for more on the change to the Stand Your Ground law is Susan Nylon of Nylon Associates and Jeff Young, a private attorney known locally as the gun lawyer. And Jeff, let me start with you. Is this a good thing?
Yes, I would say it's a good thing, and I'm not just saying that as a gun owner, as a criminal defense attorney. Anytime the burden of proof shifts to the state, who are the ones that are trying to bring the charges against you, possibly throw you in jail, et cetera, it's always a good thing from a defense attorney standpoint whenever the burden shifts to the state. Now, obviously I like it as an extra added thing as a firearm enthusiast as well, but when you take everything as a whole, whenever the burden can shift from the defendant having to prove their innocence to the state having to prove their guiltiness, that's always a better benefit for a defense attorney.
Susan, you're in an interesting position because you are a law student.
I am.
And someday you might be handling these cases. Do you have the same opinion?
I don't have the same opinion because I think of the victim of the crime and the fact that everything has to be laid out in a pretrial conference. That's a heavy burden for the prosecutor's office to be able to do, on top of the fact that they're essentially having to lay out all their cards on the table just to be able to take it to trial. And there's a lot of problems that I see with it. It's
my understanding that Florida is perhaps only one of 4 states that do this. There are a lot of states that have Stand Your Ground laws, but obviously many states that do have your Stand Your Ground laws do not go this far. Why here?
Well, I think it's reflective of what people in the state want. We have a very strong gun ownership and advocacy group in the state. They've elected representatives to go up to Tallahassee and lobby for these type of changes. We have a governor who's pro firearms and wants to sign them. So I think it's not necessarily indicative of a major problem that was in the state, but I think it's clear that based on the representatives and the laws that they want to pass, that our opinion and firearm-related people is that this is what the people of Florida want, and that's what they elected, so it was passed.
I would disagree with that.
Sure.
There was a, just because the bill is lobbied and passed and signed by the governor doesn't mean it's the will of the people. Lobbyists for the NRA have a sole purpose, and that's to get their agenda through. It's never a reflection of what the entire state wants.
Susan, that may be true, but the NRA backed a whole lot of proposed bills this past session. Only one of them really got through, and that was this one.
And that's only because they found enough people to sign on to that bill. But that doesn't mean that the public is wanting it. In fact, most of the public, it wasn't even aware that it was becoming a bill, let alone something the governor was going to sign. So to say this is what the people of Florida wanted is a gross overstatement.
There have been a number of high-profile cases involving Stand Your Ground in the last couple of years. I'm thinking about the movie theater shooting up in Pasco County. Obviously, there was another case up, I believe, in Tallahassee or Gainesville, and the terrible murder of the young black Trayvon Martin case. I'm sorry. It seems to me that you're taking something that was controversial beforehand, and now even putting it in situations where you may have a lot of close calls that really get a lot of people on both sides of this issue aggravated.
Well, our position is, and again, I'm speaking more as a defense attorney in this case than actual firearms, is whenever there's a close call, you should always err on the side of the defendant. You shouldn't err on the side of the state attorney's office or the prosecutors. So I don't think shifting the burden to them, and the burden is clear and convincing, which is one of the lowest burdens that we have in law. Simply shifting the burden to them on a clear and convincing standard is not putting a huge burden on there, and they shouldn't make a difference in any cases that they file.
All right, we're going to pick up this conversation in just a moment, right after we check on our weather. Welcome back. If you're just joining us, we are discussing Florida's Stand Your Ground law. Governor Rick Scott recently signed a bill shifting the burden of proof in pretrial hearings that cites Stand Your Ground as a defense. Now the prosecution has the burden of proof. What does it mean for these cases? Our guests tonight are Susan Nylon of Nylon and Associates and Jeff Young of the Law Office of Jeff Young, Private Attorney. Jeff, how does this fundamentally change a gun case where Stand Your Ground could be a defense?
Well, I think logistically what it changes is, as it is now, the defendant has to file the motion and they have to present the evidence. So they have to call their witnesses to try and prove that it is a stand your ground case to get it thrown out. So what it does logistically is it switches it to the state. It's their burden. So now they have to call the witnesses to prove that it's not a stand your ground case, therefore they can take it to a jury. However, the burden, as I said before, is so low. Clear and convincing is one of the lowest burdens that we have. I really don't think making that tiny little shift is really going to change any of the decisions that the state attorney's office might make. If it was a close call before, I don't think this is going to change their opinion on whether to file the charge or not, just because they may have to call a couple of witnesses in a month or two at some hearing.
Susan, you said your concern is that prosecutors are going to be forced to lay out their case before they usually would have to. So is it really that much of a difference?
Well, I think it depends on how it's played out, and you can tell me if I'm wrong, but it also depends on the judge's interpretation of the law and what he's expecting from the prosecutor. And you have to remember, stand your ground, as you said, the bar is incredibly low anyway. It's a position where you have to feel threatened. So imagine you are the reporter who got body slammed by the politician. Well, you know what? Who's to say that that reporter didn't have a gun in his pocket and as he was getting pummeled by the politician, pull it out and shoot him? Is that something we want? It doesn't take much to say, you know, I was standing my ground, because we know that you can do it anywhere at this point in time. It doesn't have to be a part of the castle doctrine, which is in your home. So when you have that burden so low, and then you have most of the victims are deceased of this, then it's completely on evidence that's gathered from the prosecution, and how much they're willing to invest in that, how much time, how much evidence they can lay out all for a pretrial hearing. I think it's a little bit of a challenge.
Let me ask you both this question. Is this change to the law going to result in more cases where defendants try to apply it?
No, because that part of the law was there regardless of whether they changed it or not. A defendant was always going to file a stand your ground motion if they believed it was a stand your ground. I don't think now they're going to say, well, because the state has to do it, why not? Let's go ahead and do it. If it was a state that there's a case that met the criteria, they were going to file it. The only issue here would be whether a prosecutor who would be on the fence on a filing decision, if normally it would be on the defendant, if they would say, well, I'll go ahead and file it and let him do all the work, or now I have to do all the work, I'm not going to file it. My belief is if the case is that bad to begin with, we're doing this tiny little bit of extra work is going to prevent you from making a filing decision, then it's probably not a very good case that should be filed in the first place. So I don't really think it's going to make any changes in the prosecutorial decision making.
Susan, do you agree that, or here's the question, is this going to result in fewer cases that prosecutors bring forward because of concerns about this?
Yeah, I mean, I agree with him. If I was to become a defense attorney, I would be very happy with all this, because all the work has to be in the prosecution's office. And, you know, it also is considered the amount of caseloads that they have as well. They will turn around and say, yeah, I'm not too sure about this case, so we're going to let it go. I just feel the focus needs to be also on the victim and the victim's family. And is it fair and just that there's a really good chance that the prosecution won't go through with it because there's a lot of gray area?
But in the way we make our laws and the current law, there are the victim's rights are often come in secondary toward the defendant's rights. And isn't that a problem that we have had to deal with for a long time?
Yeah, I mean, one can always make an argument about that. I mean, as a defense attorney, certainly my main priority is to my client, but obviously we've all been victims of crimes or know people that have, so I certainly have sympathy for those people. But I think when you're talking about giving the state the ultimate power, which is to take away your liberty and your freedoms and put you in jail, anytime you want to give the state that kind of power, you should make them do the work that they need to do to exercise that power. And I'm not going to lose any sleep or have any sympathy for any prosecutors whose caseload may be too high that they can't make that decision. Then don't arrest my client and try and put them in jail.
But in terms of some of these cases, and I'm thinking about the high-profile cases that we have often reported in the news, I would imagine it is difficult for prosecutors to drill down and find out what is in the mind of an accused shooter, before one of these incidents take place.
Especially when the victim isn't alive, to actually explain their side of the story. It's gathering all the evidence and the witnesses, and if there isn't even a witness, there's been times where there hasn't been a witness. It's a really hard case to lay out.
So is that in itself unfair? For instance, Trayvon Martin was not around to give his version of the story. There were not, I don't know if there were any eyewitnesses to that shooting.
There
so
weren't.
you're relying on what George Zimmerman said, and does that not provide prosecutors with a fair ability to prove whether or not, Stand Your Ground was a legitimate attempt at defense?
Well, but that's always been the issue, whether you're talking about stand your ground or not. The Trayvon Martin case wasn't a stand your ground case. That was a straight up self-defense case. And self-defense has been a defense since the dawn of time. So prosecutors in cases where it's a he said, she said, or a self-defense claim have always had the burden of trying to prove what was in the mind of the defendant and whether they acted appropriately. The stand your ground law hasn't changed that aspect of our law.
On the other side of that, is it possible that this could work against an accused person? For instance, I'm thinking about the movie theater shooting up in Polk County, where you had statements by the shooter's wife saying, "You did not have to do that," and other people in the audience who take issue about whether or not the retired police officer, had to shoot when he said. I mean, could it work against the defendant?
I mean, I would have we would probably agree on this. I don't think the new change is really going to make much of a difference in that. It's just placing the burden on the prosecutor as opposed to the defendant, and it's not. I don't think it's going to be that big of a difference. If there's a ton of witnesses, I would imagine the judge is going to say, "Yeah, let's take it to trial." So I'm only concerned of when there aren't any witnesses, or there's not enough time. You can't just sit on this for 6 months to a year while you gather the evidence.
Anytime that the law changes in this manner, is it a considerable amount of time before we see how the practical implications of it play out?
Yeah, I think that's clear with any kind of law that you make any changes. It's going to take a while to see how many people file these motions, how many of them succeed. There's really going to be no way to measure how many cases the state decided not to proceed on because of this new change in law. They don't usually keep those kind of records as to why they drop charges. So I think you may see an uptick in these motions being filed, but I honestly don't think you will. I don't think it's really changed the law enough to really negate what's been going on since the Stand Your Ground law was originally passed.
Is there a possibility here that as it gets applied or not applied, that the appellate and the Supreme Court will have to have their say in terms of whether or not this is even constitutional?
Well, I would say if anyone challenges the law of its constitutionality, of course it'll try to work its way up. Whether it gets the whole way up to the state Supreme Court, I don't know. And I don't know if like we've said, I don't know if there's enough of a change that is going to send up some red flags about it, because really they just shifted the burden. If anybody's going to challenge Stand Your Ground, it's going to be the law as a whole. And even then in Florida, it's been rather difficult to do.
What would both of you say to gun owners right now in terms of what they should keep in mind if they face the unexpected situations which could happen anytime, any place, in terms of the way the law is now and how it's changed from the past? Jeff?
Well, I would tell them the same thing I always tell them. When you're in that situation, the last thing you should be thinking about is, well, what about this law? What about this? Or what's the cop going to say? What's the attorney going to say? If you're in a situation where you feel your life or your family's life is threatened, you need to act however you feel you can appropriately act. Don't take the second to waste thinking about something that may happen down the line. You act, hire a lawyer, and we'll deal with it later on down the road.
Susan?
Well, I think the caution should be for the people that get engaged that are not gun owners. I would think twice about standing up and choosing a fight with someone that you just don't know how they're going to react, because it's just an unknown that to me is not worth the risk for whatever you're protecting, unless, like you said, it's your family or your home. If it's just a fight on the street, or if it's just a reporter and an elected official, let it go and walk away.
Good advice.
Well, that's always good advice.
Let's take a quick break, and when we return, we'll have final thoughts from our guests, plus what some of our viewers are saying about last night's topic, energy exploration on the Atlantic coast. Welcome back. Florida is now the only state putting the burden of proof on prosecutors in pretrial hearings of Stand Your Ground cases. Should the law have been this way to begin with, will it cause more people to cite it as their defense? Our guests join us right now for final thoughts. Susan, you take a guess.
You know, I'm sure the prosecutor's office or the state's attorney's office is going to say no because they're already overburdened and overtaxed on issues. I think there are bigger issues regarding stand your ground and the gun laws and everything else that we really need to take a look at. I would not be as concerned, except, again, if you're the victim or your loved one is a victim and is not there to defend themselves for it.
Jeff, were there bigger problems with stand your ground in Florida, and should that have been worked on before this?
Well, I don't particularly see, I mean, it may come as a surprise to you, I don't really see any problems with the stand your ground. It's a law that I agree with as a gun owner, and even as a defense attorney. Again, I always think that if the state is going to do something as serious as arrest you and attempt to take away your freedom, the burden should be on them to prove that they have the right to do so. It should never be your job to prove that they shouldn't do that. And anything, whether it's firearm related or drug related or anything that puts more of the burden on the state than on the defendant, I'm always going to be in favor for.
Susan?
You know, again, with the exception of if you're actually the wrongdoer, it's a really good opportunity to take advantage of a situation. So you're the one who sets the person up, or you're the person who does the assaulting first. You know, that's an advantage that you're going to get that you wouldn't normally have gotten if the burden was on the defense.
All right, we'll have to leave it there, but before we go, we want to share with you what some of our viewers are saying about last night's topic, energy exploration on the Atlantic coast. President Trump is reversing an executive order by President Obama. Now companies will be able to search the Atlantic using seismic air guns to determine if there are oil and gas reserves. Environmentalists worry it could hurt marine life and could eventually lead to ecological disasters on our shores. What are some of you saying? Patrick McCarthy writes, I'll be honest, I'm a not in my backyard on this one. And Kyle writes, FYI, you'll abandon your cause of not in my backyard when it starts affecting your livelihood. Proof that the eco way of life is a social cult. Wow. And Susan Patton writes, can't leave anything alone, can we? If there is a way to make a few bucks, but it totally screws up what is beautiful, go for it. The money is way more important. Excuse me, I think I'm going to be sick. Okay? Well, what do you think about the changes to the Stand Your Ground law? Join the conversation by visiting our Facebook page at facebook.com/news@7. FYI, you can watch past discussions on demand. They're available on Apple TV, Amazon Fire, and Roku. Thanks to both our guests for being here tonight. Jeff Young is a private attorney at the law office of Jeff Young. He is also known locally as the gun lawyer. And Susan Nylon is the CEO of Nylon and Associates.